Well, good evening, ladies and gentlemen, and thank you for taking the time to join us this evening. My name's Brendan Thomas, and I'm the Chief Executive Officer at AUSTRAC. And before I start, I'd just like to acknowledge that I'm coming to you from the beautiful lands of the Gadigal people here in central Sydney and pay my respects to the Gadigal people and the elders of this beautiful country. So in this evening's presentation, we'll discuss the future of Australia's anti-money laundering and counter-terrorism financing regime and what the upcoming changes mean for you. First, I'll provide a high-level overview of the reforms and their relevance to your sector. And then Katie Miller, who's a Deputy CEO in charge of our regulation division at AUSTRAC, will then cover the finer details of the reform and their practical application to your business. And throughout this session, we have a Q&A option set up so you can ask any questions that you like, and we have a team on hand who can assist in answering those questions. At the end of Katie's session, we'll address common questions that arise throughout this evening. Now, overall, we expect this evening's session to last for about an hour, so finishing at 7 p.m. this evening. And again, thank you so much for taking the time to join. We'll also be recording this session so that it'll be available on our YouTube channel tomorrow. Just before I go into any details, it's important to note that today's content does not constitute legal advice. It does not go into every detail of the law or indeed into every situation that you might face. So I encourage you to familiarise yourself with the guidance on our website, and if you need to, consider obtaining your own professional advice for each specific and individual need that you might have. But firstly, I want to draw your attention to the scale of money laundering in Australia. In November 2025, the Australian Institute of Criminology released its latest report on the costs of serious and organised crime in Australia. Now, if we look at just one type of crime alone, that's drug dealing, we know through the good work of our colleagues at the Australian Criminal Intelligence Commission that the value of the Australian domestic drug market is at least $19 billion a year. Think about that. That's $19 billion, every dollar of which is illegal money. And all that money is laundered through the Australian economy every single year. And that's only one single type of crime. This is part of serious and organised crime that's costing Australia up to $82 billion a year. That's equivalent to 3.2% of our nation's gross domestic product. And globally, a conservative figure puts that at $2 trillion. Of the total money being laundered through the Australian economy, the top three costliest crimes were, as I just mentioned, illegal drugs worth up to $19 billion, organised financial crime, so scams and other financial crime, up to $13.2 billion, and other illicit commodities like illicit tobacco and intellectual property crime, representing another $8.6 billion. While serious and organised crime is most visible in our own communities and in our economy, it also shapes how Australia is viewed internationally. To give you an example of the scale and sophistication of money laundering operations, one such operation that was dismantled in Australia by the AFP with AUSTRAC's strong assistance, this criminal group operated as a criminal remittance and banking service, able to make significant sums of money available to clients almost anywhere in the world within 24 hours. The organisation moved an estimated $10 billion over 4 years and had the capacity to move up to $1 million an hour. It was so large, it even set its own exchange rates. The organisation had a sophisticated informal value transfer system in place to make funds available overseas. By exploiting digital currency trading, domestic and foreign shell companies, and multiple offshore bank accounts, the organisation effectively operated as an underground bank with global reach. To be clear, the reforms to the Australian anti-money laundering law aren't just about stopping Australian criminals. They're also about stopping international criminals parking their dirty money here in Australia. This money pushes up property prices. It takes property that would otherwise have been purchased by an Australian and puts it into the hands of organised criminals whose only purpose is to continue their cycle of crime and harm. We see time and again that property is used to layer and integrate illicit funds, often unknowingly facilitated by professional advisors and real estate agents. Those professionals who are in a unique position to spot this suspicious activity currently have no legal obligation to do so. The anti-money laundering laws aim to close these gaps and in the process to protect your business and your staff from criminals who at the moment know that your sector can be exploited for their benefit. And if we're seen as a weak link, we're the target for global crime networks and risk losing credibility with other countries and the credibility of our financial institutions. This could mean countries not wanting to continue to trade or transact with us, or making that trade more expensive because of additional risk. We also have an international obligation to meet global anti-money laundering standards. The reforms to the Australian Anti-Money Laundering Act are not just about stopping Australian criminals, but they're about closing our market to international crime syndicates and making sure Australian real estate is not a safe haven for dirty money. And this is where AUSTRAC comes in. AUSTRAC, or our title more fully is the Australian Transaction Reports and Analysis Centre, is Australia's anti-money laundering and counter-terrorism financing regulator. Through this evening's session, you'll hear us shorten that to AML-CTF. AUSTRAC is also Australia's financial intelligence unit. We regulate businesses to stop criminal abuse of the financial system, and we work with our partners to protect the community from serious and organised crime. AUSTRAC helps build resilience in the financial system and enables us to use financial intelligence and regulation to disrupt money laundering, terrorism financing, and other serious kinds of crime. Right now, AUSTRAC regulates around about 19,000 businesses across sectors like finance, banking, bullion, and gambling. The services these businesses provide are known as designated services, and they're known to pose higher money laundering risk, terrorism financing, and proliferation financing risks. But from the 1st of July this year, AUSTRAC's regulation will expand to around about 100,000 entities due to the reforms of the AML-CTF Act. New services and entities, including lawyers, accountants, real estate agents, and dealers of precious metals and stones, collectively and colloquially known as Tranche 2, will come under our regulation. Now, in 2024, AUSTRAC released our National Money Laundering Risk Assessment, and in that assessment, we assessed lawyers as presenting a high and stable money laundering vulnerability in Australia. This reflects the reality that lawyers can be used, sometimes knowingly, often unwittingly, to facilitate money laundering through the provision of legitimate professional services. Law enforcement agencies consistently identify criminals actively seeking out and exploiting legal services to legitimise criminal activity and to obscure the proceeds of crime. Domestic criminals often rely on lawyers working alongside other professionals like accountants, financial advisors, and offshore service providers to conceal illicit funds and hide their beneficial ownership. Key vulnerabilities include the misuse of law firm trust accounts, the facilitation of real estate and other high-value transactions, and the creation and administration of complex legal structures, including trusts and companies, and sometimes involving nominee arrangements. The involvement of legal professionals as gatekeepers or facilitators of money laundering is recognised through that national risk assessment as an enduring vulnerability, both domestically and internationally. While AUSTRAC's direct visibility of suspicious transactions involving lawyers is currently limited, secondary reporting we get from banks shows that lawyers handle large volumes of cash and international funds transfers, which increases vulnerability to this kind of exploitation. And client risk varies significantly. Vulnerability is heightened where clients use third parties to obscure their identity or their beneficial ownership, particularly in the absence of formal customer due diligence obligations. But to help explain the AML-CTF law changes, we've developed a short video, and we'll play that video for you now.
Every day in Australia, billions of dollars move through our economy, from property settlements and business deals to the purchase of luxury items like gold, diamonds, and other precious gems. While most of these transactions are legitimate, the unfortunate reality is that some are used to fund serious crimes, like drug trafficking, human exploitation, and weapons dealing. This happens through a process known as money laundering, where money gained illegally is moved through layers of transactions to hide where it comes from. That's where AUSTRAC comes in. AUSTRAC is Australia's financial intelligence unit and financial crime regulator. We work with law enforcement, government, and industry to detect and disrupt criminal activity hidden within the financial system. Until now, anti-money laundering and counter-terrorism financing laws have mainly applied to businesses like banks, casinos, pubs and clubs, remittance service providers, and digital currency exchanges. But that's changing. From the 1st of July 2026, more professionals, including real estate professionals, conveyancers, lawyers, accountants, and jewellers, may have obligations under the law. These are all sectors that facilitate large transactions which criminals can exploit. Under the reforms, you may be required to assess the risk of how your services may be used to launder money. Know your customer's identity and verify the source of their funds. Maintain accurate records and report suspicious transactions to AUSTRAC. You're not in this alone. AUSTRAC will provide guidance, tools and training to help you meet your obligations with confidence. These changes are not just about ticking a box. They're about protecting your clients, your profession and the wider community. Together, we can stop crime where it hides.
As we said, today the focus of Australia's AML legislation is primarily on traditional financial institutions like banks and casinos. But however, as criminal methodologies have grown more sophisticated, it's become clear that there are gaps that remain. And the Australian government has recognised these vulnerabilities and through legislative amendments moved to align our national framework with broader international standards. Those reforms passed in November 2024, marking a historic expansion and bringing, as we said, that broader range of professional service providers within the scope of the AML-CTF regime. And this expansion is not merely legislative housekeeping. It's a necessary response to the increasing complexity and scale of financial crime in Australia and around the world. Australia's compliance with AML-CTF is governed by the standards set by the Global Financial Action Task Force, or FATF for short. The FATF is the global money laundering and terrorism financing watchdog, and it's responsible for setting international standards and for conducting mutual evaluations on member countries. These evaluations focus both on technical compliance, whether the right laws and regulations are in place, and also on effectiveness, on whether those measures work in practice. These standards require lawyers to comply with AML obligations, and Australia is one of only 5 FATF member countries that has not yet implemented these reforms. Comparable jurisdictions like the United Kingdom and New Zealand have regulated these professions under their AML-CTF regimes for some years now. Ahead of Australia's next FATF mutual evaluation, it's important that we understand both when it starts and what it will assess. Australia's mutual evaluation by the FATF is scheduled to be conducted this year and to conclude in 2027. Assessors will look closely at how our AML-CTF framework actually works in practice, not just what's written in the legislation. And the mutual evaluation has 2 core components. The first, as I said, is its effectiveness. Assessors require evidence that our AML-CTF measures are producing real-world results that appropriately mitigate money laundering, terrorism financing, and proliferation financing risks. And the second is an assessment of our technical compliance, which examines whether Australia's laws, our regulations, and our legal instruments meet the FATF's 40 recommendations. And our technical compliance submission is due at the end of this month. Both need to be strong. Having good laws is not enough unless they are implemented effectively. But legal professionals play a crucial role in financial and property transactions, and in corporate structuring and in trust management. Unfortunately, this expertise and access also makes the sector a target for organised criminals seeking to launder illicit funds. A criminal may seek legal assistance to appear legitimate in their illicit transactions. For example, legal services may be used with the intention of transferring funds through a law firm's customer accounts. This could be to either legitimise the funds or to use the firm's professional status to enhance the legitimacy of the transaction. Money laundering is facilitated by concealing the connection between the perpetrators and the proceeds of their crimes. Lawyers may unknowingly be involved in money laundering activities where their services are used for depositing and transferring or withdrawing funds. I'd like to share with you a recent example of AUSTRAC and law enforcement's efforts to highlight the critical role financial intelligence plays in supporting these kinds of investigations. While it's not an exhaustive example, it will give you a sense of the types of work financial intelligence does to support the outcomes of these kinds of operations. So in this example, the ATO commenced a risk review into an individual taxpayer suspected of tax evasion. When the ATO made contact with the individual taxpayer, the person was represented by a lawyer. The ATO ran the lawyer's name through the AUSTRAC database and identified millions of dollars in wire transfers between the lawyer's trust account and an offshore bank account. The bank with which the lawyer's trust account was held had submitted international funds transfer instruction reports to AUSTRAC. However, that bank was unaware of the source of those funds as it had come from another institution. That meant they were unable to establish who the funds were coming from. It was only when the ATO had already taken an interest in the individual taxpayer, based on other sources of intelligence, that they were able to draw the link between the individual taxpayer and this substantial amount of suspected diverted taxable income going through the legal trust account. If the lawyer at that time had have been subject to AML-CTF obligations, they would have had to identify the channeling of significant funds through their trust account to an offshore bank account to be potentially high risk. Additionally, they would have had an obligation to undertake enhanced customer due diligence, including taking reasonable steps to identify the source of the customer's wealth, analysing the purpose of the reasons and the nature for the transactions. This may have led to an earlier detection of criminal activity and the prevention of further proceeds travelling offshore. But over the past 12 months, our focus has been on building awareness, ensuring businesses understand that this reform has been coming and what the expanded regime would look like and how it might apply to them. We're now moving into the next phase. The conversation is evolving from awareness to one of preparation. Over the past 6 months, we've progressively released key materials to support that shift. We've published new AML-CTF rules, released our core guidance, and at the end of January, we published our program starter kits. Taken together, these products move us beyond high-level awareness. They're practical tools designed to help businesses begin considering how the regime will operate in their own context. Our engagement is also evolving. We'll continue to work closely with industry associations and their members, not only to explain these reforms, but to support practical readiness conversations. Now is the time for businesses to begin engaging with AUSTRAC's education products, reviewing the AML-CTF rules and the core guidance, and becoming familiar with the program starter kits. It's an opportunity to start thinking about what an AML-CTF program may look like in your business, to begin identifying and understanding risk, to understand your AML obligations, and to begin to prepare your AML-CTF program. This is the stage where concept begins turning into operational thinking. As we've discussed this evening, 2026 will be a significant year, a year of change and a year of transition. For yourselves, it's about preparation and building a strong foundation for compliance. It's also a year that highlights the shared responsibility that we all have in combating financial crime. The reforms are designed to strengthen Australia's financial system, to protect our communities and ensure our frameworks remain fit for purpose, but their success depends on all of our collaboration. At AUSTRAC, we remain committed to working alongside you throughout this period. We'll continue to engage with industry, provide practical support, and respond to questions and challenges as they arise. But I encourage you to take an active role in this transition. Engage with AUSTRAC's guidance, attend and participate in forums like this one, workshops and working groups, and stay informed, and maintain open dialogue with us. Together, we can ensure that reforms are implemented effectively and that Australia's AML-CTF regime continues to operate with integrity, resilience, and make a strong impact. And now I'll pass the virtual mic over to my Deputy CEO for Regulation, Katie Miller. Katie.
Thanks, Brendan. Good evening, everyone. My name is Katie Miller and I am the Deputy CEO for Regulation here at AUSTRAC. So that means I hold the strategic responsibility for AUSTRAC's regulatory policy and legal functions. As Brendan mentioned, I will be discussing how the changes to Australia's anti-money laundering laws will impact you as legal practitioners. I'll talk about your obligations under the new laws and our expectations as a regulator. I'm also going to touch on how we're helping you to navigate these changes and some of the support and resources available to you, which Brendan has mentioned. Also, as Brendan explained, we have the Q&A function open and our team is on hand to answer your questions, so please keep those coming through, and we have got some time at the end of my presentation to respond to some of the common questions. So let's get started with the first question of who is going to be regulated. Now, the first point that I want to make is that the AML-CTF Act does not regulate based on sector. It regulates based on what are called designated services. So these are particular types of services that have been recognised globally as being at higher risk of being abused by criminals to launder money. And some of those designated services are commonly provided by legal practitioners. So from 1 July 2026, so 1 July this year, if you provide one of these designated services, you will be regulated by AUSTRAC and you will have core obligations under the AML-CTF Act and rules. Now, if you've got the amending act handy, the one that was passed in November 2014, you can actually see a full list of these designated services. They're in a table at section 6, and so you can use that to see whether your business provides any of those designated services. We also understand that, amending legislation can be somewhat unwieldy, so you can also use our Check If You May Be Regulated tool, which is on our website, and that'll provide some guidance about whether you might be within or without the regulatory perimeter. And we'll show you how to access that tool in a later slide. Now, the important point to take home tonight is that the Act does not cover all services provided by lawyers. For example, it does not cover criminal law services. The services regulated, the designated services, they are those that involve the transfer of value, such as money, property, and other valuable assets. So some examples of what are designated services that are regulated. So the first one involves the transfer of property. So if you execute or act for your client in a transaction for the sale, purchase, or transfer of real estate from one person to another, you're providing a designated service. And in that case, if you've got a known purchaser and seller, the designated service can include both the execution and planning of a property transaction. If you sell or transfer a shelf company in the course of carrying on a business, you're providing a designated service. That includes assisting or otherwise acting for on behalf of a person to plan or execute a transaction to buy, sell, or transfer a shelf company, or otherwise acting on behalf of a person in the creation or restructuring of a shelf company. Now, there's been a lot of discussion about what assisting and sort of planning involves. The designated service does not extend to advice that merely influences a decision to set up such a company. So, for example, if you're providing advice to clients about the best way of structuring assets to support certain business or family objectives, that advice is considered to be merely influencing. It's not a designated service. The point at which you actually start giving advice or sort of assistance on how to implement that or actually doing the implementation, that's the point at which we've got a designated service. Another designated service that some of you might provide is providing a registered office address or principal place of business address of a body, corporate or legal arrangement. So this occurs when you've got a client who doesn't necessarily operate from your address, but nevertheless uses it for their address that they have with ASIC. And the reason that that designated service is regulated is because those services can contribute to the anonymity in which people can deal with money. So that's another regulated one. Another point to mention about designated services is that they will have clear start and end points. A lot of the services that we're talking about are transactional, and so they will have a clear beginning and end. And your obligations are for the period that you are providing the designated services, and that may be a shorter period than your overall customer relationship or retainer. And that'll become relevant when we come later on to talk about what your obligations are and what you're expected to do to meet them. So if we move on to what your obligations will be if you are providing designated services. Effectively, the obligations that you will have are all directed towards helping you to mitigate and manage the risk that the services you provide will be abused by criminals who are trying to launder money through your business. The key obligations that you will have, first, you will need to enrol with AUSTRAC, and you need to do that within 28 days after you provide a designated service. Enrolment is effectively letting us know that you exist and that you provide the designated services. The next thing you'll need to do is develop and maintain an AML-CTF program that is tailored to your business. And so that needs to include a risk assessment, which effectively identifies and assesses the money laundering, terrorism financing, and proliferation financing risk that your business may face in providing the designated services. And then you need to have some policies and procedures that will manage and mitigate your business's risk. And those policies also need to address how you will comply with your own obligations under the AML-CTF Act. And they need to be appropriate to the nature, size, and complexity of your business. You'll also need to appoint an AML-CTF compliance officer. They will be the person in your organisation responsible with overseeing and coordinating the day-to-day compliance with the Act and rules and the policies that your business has developed. Now, depending on the size of your business, that compliance officer may be solely focused on AML matters, or they may have other duties in addition to AML. However they are, they must be considered a fit and proper person at the management level. Now, if they are a lawyer, you can rely on the fit and proper person test that is part of standard legal professional standards, with some additional considerations that are relevant to the person's AML-CTF knowledge and capability. Now, they don't need to be an expert in AML-CTF, but they do need to have done some training. And you can find the considerations that are relevant to determining whether somebody is suitable to be a compliance officer in the AML-CTF rules. The next thing you need to do is you need to conduct initial and ongoing customer due diligence. So this is effectively knowing who your client is. It involves knowing and verifying your client's identity. So you know who they are and that they are different to everybody else. And it also involves understanding the nature of your business relationship with them. So effectively, why are they seeking these designated services from you? Now, for a lot of you, you will already be doing a lot of things to know who your clients are. If nothing else, it helps you to provide better service. And so a lot of the obligations around customer due diligence and knowing your customer or your client may simply amount to either leveraging off your existing processes or formalising what you already do. Customer due diligence helps you to understand who your clients are and the money laundering or terrorism financing risks that they may bring to your business. The level of information you collect and verify to complete customer due diligence will depend on the risk profile of the customer. Not all customers are alike and their risks are not alike. You will deal with some low-risk customers, you will deal with some high-risk customers. That's important because the Act adopts a risk-based approach. It is not a one-size-fits-all approach. It is about different controls are needed depending on the level of risk that a particular customer, service, or channel presents. That does mean that you actually need to make an assessment of the sort of level of risk that your customer presents. And if your customer risk is low, then you can apply provisions in the Act that effectively allow for a less stringent form of due diligence. So we call that simplified due diligence. And an example of a low-risk customer might be an individual resident in Australia who asks for help setting up a private company as the sole director and shareholder. In those circumstances, it's very clear who still owns and controls the company and any assets of the company, and so lower risk of it being used to launder money. And so for that sort of customer or client, it might be enough to gather some basic information from them, check their driver's license against this information so you can say, yes, they are who they say they are. Do a couple of internet searches to see if they're subject to international sanctions or if they're what's called a politically exposed person. And if they come back, and the reason that we still need to do those checks is because it's quite common for organised crime to hide behind law-abiding citizens. So people who look like they're low risk and look like they are not involved in crime, they become a really easy person for crime to hide behind. So we do still need to do some checks. The initial customer due diligence needs to be carried out before you provide the designated services, although there are some circumstances that the Act provides where you can delay that customer due diligence where it would disrupt the ordinary course of business. You don't need to do customer due diligence on existing customers. So if you have a relationship with a client before 1 July, you'll only need to do customer due diligence on them if you ultimately need to submit a suspicious matter report about them, or if there is a significant change in the relationship that increases their risk to medium or high over the course of your relationship with them. The next obligation that you will have is to submit reports to AUSTRAC, and there's a range of reports that you need to submit. So the one that we anticipate will be most common for lawyers, and it won't be huge numbers, but it is probably the one that you'll encounter the most, is the suspicious matter report. So when you suspect on reasonable grounds that a person is not who they claim to be, or that a matter is linked to criminal activity or proceeds of crime, you need to tell us about that. You need to provide a report. Now, one of the queries that we have received a lot is, is a suspicious matter report the same as reporting a crime? The answer is no, it is not. A suspicious matter report is what it says on the label. It is a report of a suspicion around a particular matter. It's not a full police report. It is not something that law enforcement can pick up and just act on straight away. What it is a piece of intelligence. And one of the roles of AUSTRAC is to take all of the reports and data that we have access to and produce what is known as actionable financial intelligence, which is then shared with our law enforcement and intelligence partners for them to use in their investigations. The next type of report that you might need to submit is a threshold transaction report. So that's a report where you have individual cash transactions of at least 10,000 Australian dollars or the foreign currency equivalent. And then finally, all regulated businesses are required to submit an annual compliance report, and that provides information to AUSTRAC about how you are managing your money laundering risk consistently with your obligations. And then finally, and this won't be a surprise for lawyers, you do need to make and maintain accurate and complete records and hold those for at least 7 years. And those records will provide evidence of your due diligence, your risk management practices, and how you have complied with your AML/CTF obligations. Now, moving on to how you can understand more about these obligations. Now, of course, you're all lawyers, so you can understand your obligations by reading the legislation. Equally, we understand that you're quite busy, so you may not want to go that option. So we have actually produced a plain language version of the obligations in our core guidance. And that document also contains AUSTRAC's positions on a number of issues, which could include our interpretation of some of the provisions in the legislation, as well as our expectations of what we think is needed to meet those obligations. Our core guidance is available on our public website, and it is designed to be a central reference point for all reporting entities as they update their compliance approaches. And you may see that, as people are asking questions in tonight's session, our team is sort of pointing people to that guidance. The purpose of the core guidance is to provide practical and accessible insights into how AUSTRAC interprets and expects entities to implement the new AML/CTF reforms. It contains information about AML/CTF programs and our expectations around risk assessments, program structure, assurance processes and record keeping. Information around customer due diligence, including what it means to apply the risk-based approach, and some guidance on beneficial ownership and ongoing client monitoring. And then it also provides some information about governance and oversight. So for those of you who are in firms involving more than one person, there are requirements around your governing body, whether that's a board or a group of partners, having visibility, having your senior management accountable, and having clearly defined roles and reporting lines. Now, when you access the core guidance, I know that as lawyers, there's something quite satisfying about reading an act from cover to cover. That is not how the core guidance has been designed. It's not designed to be read cover to cover. It is a reference tool to dip in and out of as you progress through your AML/CTF journey and as you have questions arise. Each section has links to the relevant sections of the AML/CTF Act and rules if you want to see the detail, and it also explains what the obligation is as a reporting entity. Now, you recall that one of the obligations that regulated businesses have is to have an AML/CTF program. As Brendan mentioned, we have recently released program starter kits to help typical small businesses in the newly regulated sectors, including the legal sector, to build an AML/CTF program that will meet their obligations. Now, these program starter kits, they are a world-first initiative. No other regulator globally has done something like this, effectively stand in the shoes of the regulated business and go through the exercise of what a regulated business will do. The program, and we've done that because we see a lot of value in it, both for yourselves, but also for AUSTRAC in the sense of getting to a point where we are plugging more of the holes and vulnerabilities in our sector and making it harder for organised crime to launder their money. Now, the program starter kit set out practical step-by-step actions that businesses can take to build your own program. Now, it's not a template. It's not something that you sort of copy and paste into your own process. Rather, it's a product that you can customise to reflect the nature of your business. And the kit includes a guide on how to customise the documents to reflect your business and the risks that it faces. These resources have been designed to help smaller businesses in the tranche 2 sectors to reduce the time, cost and effort involved in developing an AML CTF program. And so there are some limits, or there are some sort of indicators of what we consider to be an appropriate user of these kits. So it's appropriate for use or customisation if you are providing conveyancing, if as a legal practice you're providing conveyancing services or services relating to body corporates and legal arrangements. It's suitable for practices with 15 or fewer personnel. Now, personnel includes all your personnel, so administrative staff as well as legal practitioners. It's suitable if you've got some or all of your personnel providing designated services or operating under a legal practicing certificate. If you're attending tonight and you've got a conveyancing practice but you don't have a legal practitioner certificate, then the better kit for you to use is the conveyancing program starter kit. It's suitable if you most commonly deal with individual clients who are Australian residents, it's less common for you to deal with body corporates, legal arrangements, or overseas residents. Suitable if you don't regularly deal with high-risk clients. Doesn't mean that you can't deal with high-risk clients, but they're not the sort of primary group that you're dealing with. Suitable if you don't assist with the purchase, transfer, or sale of overseas property or provide fully remote self-service options that allow clients to obtain designated services without having any interaction with your staff. It's suitable if you don't sell property that you own yourself or you aren't acquiring all or part of another practice or aren't transferring clients from another practice. There's some separate procedures that relate there. And it's suitable if you're not part of a large reporting group, foreign branch, or subsidiary. Now, as I've been going through those sort of suitability criteria, if one of those suitability criteria didn't apply to you, don't worry, you can still access the program starter kit. They are available on our website for anyone to have a look at. And you can definitely use the program starter kit to use it to inform or inspire your own AML CTF program. However, if you don't meet the sort of suitability or sort of expected user features, you remain responsible for assessing which materials are appropriate for your business's circumstances and identifying how to address your specific money laundering and terrorism financing risks. And the reason for that is that if you've got a legal practice that is outside the intended users of the kits, you'll probably face different and more complex money laundering risks than those that are addressed by the program starter kits. And those sorts of more complex risks generally require stronger or additional controls, as well as different due diligence processes and policies. Some of the practical examples and guidance in the kits may provide context or understanding, but they're not tailored specifically to the management of more complex risks. But we do think that the kits are a highly informative reference, even for businesses that don't fit the intended user profile. So we do encourage you to have a look at them. The kits, as I said, they provide customised guides that sets out step by step the actions you take to build your program. And they contain the elements that you need for a program. So a risk assessment, which identifies the common risks that you will face if you're providing the particular designated services, so conveyancing or the professional services associated with body corporates and legal arrangements. There'll be a policy document which sets out essentially the policies of what businesses need to do and when to meet their AML CTF obligations. And then some processes and forms. So actual checklists of questions you need to ask and answer to, assess a client's risk, to understand more about why they're seeking your services, and the information that you need to collect based on the level of risk that they pose. And we've also got a number of forms that you can provide to customers and clients so that you can easily gather that information. And so what our expectation is that these resources help you to save time, cost and effort involved in developing an AML CTF program, so you can put more of your effort into applying that program and actually asking questions of clients, and where you see a suspicious matter, raising that to our attention. The program starter kits have been, like I said at the beginning, that they were a world first, and it's the first time that, you know, a regulator has sort of stepped into the shoes of a regulated business. Can I say we did not do this alone? These program starter kits have been developed and would not have been possible without the close collaboration with the newly regulated sectors. And that includes both peak professional bodies, including legal professional bodies, and small businesses across the newly regulated sectors. And so if you are one of those people who have been involved in helping us develop these kits, I sincerely thank you. We also intend that the program starter kits are going to be living documents. So that means that as circumstances change, and in the money laundering space, things change regularly, we will be able to update those kits so that you always have access to information and controls to manage the risks that exist. Now, we understand that a new regulatory regime, especially in an area like money laundering, which, let's face it, if you're a law-abiding person, you do not spend a lot of time thinking about money laundering, and you probably don't have a lot of early knowledge about what it even looks like. It can be pretty overwhelming and confronting. And that's why we've released a number of key products to support and assist businesses through those changes. The program starter kits being one, core guidance being another. We've also got risk guidance that's specific to specific sectors. Brendan mentioned that last year he released a statement on AUSTRAC's regulatory expectations for the implementation of the reforms. And we did that because we want to make it clear what we expect and where we want you to focus your efforts. And to cut a long story short, we do not expect perfection on day one, but we do expect to see effort. Now, when you read that statement, you'll see that we've got expectations in there for our currently regulated businesses as well as our newly regulated businesses, and the support and guidance that we'll provide to them. So if you're a legal practitioner, you're providing designated services and you're going to come under regulation from 1st of July, the expectations that we have of you are, number one, be enrolled as a reporting entity. Enrolment opens and is available from the 31st of March 2026, but the expectation is that you will have done that process by the 1st of July. The next is that you have an AML CTF program. You can have that either because you've gone through the program starter kit and built one using that kit, or you've developed one on your own, possibly with some external professional advice. We expect that you will have an AML CTF compliance officer, and we expect that you will have trained your staff on your AML CTF program. And then finally, we expect that when 1 July comes around, that you're ready to engage with your clients and follow the procedures that are in your program. And if you see a suspicious matter, that you report that to us. Now, again, I recognise that these obligations are new, and for some of you, the concept of money laundering will also be new. Organised crime, they are sophisticated in their methods of hiding money and transferring value. Spotting suspicious behaviour, it is a bit of a practice. It's something that will improve over time as you learn more about how money laundering arises, and we learn more about what money laundering looks like in your sector and how it can be controlled effectively. So we don't expect you to be perfect on day one at identifying and controlling money laundering risks. We also don't expect you to stamp out all money laundering. Like crime, it is something that we seek to reduce, but we know that we will never eliminate it. But as I said before, we do expect honest efforts to meet your obligations and report suspicions to AUSTRAC. Our support for regulated businesses will continue beyond 1 July. So yes, we're doing a lot to support and educate people now. That will not stop on 1 July. We will keep doing that. We know that there will be a lot of questions, and where we have a position on something, we will connect you to the right piece of guidance or education. There will be some parts of the legislation that we have not turned our minds to yet. So if you have a question and we cannot provide you with a solid answer or position, we still expect you to turn your own mind to the question and develop your own position. And in doing that, you might wish to seek your own professional advice. We then expect you to document that position and why you consider it to be a reasonable position to adopt, and then keep records of that position and any advice that might have informed that position, and then act in accordance with that position. If we form a different view later on, we will have a conversation with you about it. We recognise that with legislation, it is that there can be matters on which reasonable minds matter. So we would start with a conversation. So look, we've talked a lot about what we've done in the past. There's been a lot of activity since the legislation was passed 16 months ago. We've finalised the AML-CTF rules. We've published our core guidance. We've published the program starter kits. And in, 21 days, so 3 weeks' time, enrolment will open for newly regulated businesses, and the obligations will start on the 1st of July of this year. And throughout this year, you will continue to hear from us as we continue to promote awareness about the reforms and provide education about what they mean for new businesses. We have launched a national phased awareness campaign, and that is all about helping sectors to understand their obligations and navigate the transition with confidence. And as Brendan said, we're currently in the preparation phase. We will soon move to the enrolment phase. So how can you prepare for the reforms? Well, congratulations by attending tonight's seminar. That is an important first step because you're basically sort of understanding what the Act is, what the obligations will be. The first thing you really need to understand is, are you providing a designated service such that you will be regulated? So highly recommend that you use the Check If You'll Be Regulated tool on our website. For some of you, you may be providing multiple designated services. Once you are providing a designated service, you are regulated. So I think that where there are some edge cases or where there are circumstances where you might be regulated, my strong recommendation at this stage is be conservative in your assessment and register and enrol based on designated services that you either do provide or you anticipate you are likely to provide in the future. Enrolment is something that can be updated along the way. If as you prepare your program, you get the sense that actually, I thought I was providing this designated service, but now I work through what's actually involved, I'm not, you can always update your enrolment. You also need to begin to develop an understanding of where in your business you might be exposed to money laundering risks. So that means sort of considering the types of clients you deal with, the products or services you offer, and how transactions and financial information flow through your business. And start having a think about what controls or systems or processes do you currently have in place that might be leveraged to manage money laundering risks. You then need to understand your obligations. So like I said, being here tonight is a great first step. Have a look at the core guidance, have a look at the program starter kits, and if you are one of the intended users for the program starter kit, start to develop your AML-CTF program with that kit. Otherwise, you will need to develop a program yourself. And finally, encourage you to engage with AUSTRAC guidance tools and education, of which we have quite a lot. And if we move to the next slide, I can tell you more about that. So we've got education materials that include e-learning modules, fact sheets, checklists, and other digital resources such as webinars. And these tools have been designed in a way that can help you grasp the basics of what you need to do. And then the guidance resources really go into the detail of different obligations. Specific to the legal profession, we have published a quick reference guide to support legal practitioners to undertake a money laundering and terrorism financing risk assessment. So that'll help you understand the risk-based approach. And we also have an essential webinar series. So that's made up of 4 webinars about what AUSTRAC is, what the AML-CTF obligations are, what money laundering, terrorism financing and proliferation financing risks look like, and what you can do or what you need to think about if you are considering outsourcing some of your AML-CTF functions. All those webinars are available on our YouTube channel. In addition to yourselves, they are also a really useful resource for some of your staff. And we are going to be releasing further webinars this year on matters such as how to use the program starter kits, customer due diligence requirements, and risk assessments. So I'll stop there in terms of the prepared remarks because I know that a number of you do have questions. So thank you for taking the time to engage with us so far. I really appreciate your willingness to listen, but I think it's time to turn to some questions. So Brendan, do you want to read out the first question that we're going to
Yeah, the first one
address?
we've got is why does the legal profession need to be regulated since banks and other financial services are already covered under AML laws? So there's two answers to that question. One is we still see money being laundered through professional facilitators and professional service providers. The banks do provide really important controls to control transactions and to limit the ability for money to be laundered, but we still know illicit funds gets through bank accounts and through financial services. But also it's really important to know that lawyers and other professional services see the transaction from a different perspective and often pick up different kinds of risks that aren't available or aren't obvious to a bank who may not be dealing with a person face to face or may not be in a position to understand the nature of the risks that present themselves, where a person in a legal profession might be able to understand what looks suspicious in the context of dealing with those particular clients. The second reason is Australia needs to comply with its global obligations under the Financial Action Task Force standards. And Australia, as I mentioned earlier, is one of few countries that aren't covered by these provisions. And for Australia to bring itself into line with the rest of the world, this legislation has been introduced and these regulations are coming into effect. Anything you'd like to add on that one, Katie?
I suppose I'll just say that these are services that have been recognised internationally as being of high risk. That means that we see money being laundered through some of these services every day. A good one is property transactions. So I think it's in the last sort of 5 years, 2/3 of the property that has been seized under proceeds of crime legislation is property transactions. So property is property. So that's all been, bought and sold using professional service providers, some of which will have had lawyers involved. Now, that doesn't mean that lawyers have been complicit with all of those sales, but it does mean that money has been laundered through, services that they have provided.
Another question is about what's AUSTRAC's enforcement posture after the legislation and the responsibilities commence. So Katie mentioned earlier that we released a statement of our expectations last year, and you can certainly see that on our website. And as Katie said a number of times, we don't expect perfection from day one, but we do expect certain things to occur, that you're enrolled with us, that you've got an AML-CTF program in place, that you have an AML compliance officer, that you've trained your staff, and that you're ready to start to ask questions of your customers and to report matters of suspicion when those suspicions arise. We don't expect perfection. We know that there's going to be challenges in implementing this new regime. And as Katie mentioned, we know that this is brand new for people. Many of you have never dealt with AML regulations before, and many of you have certainly never turned your mind to money laundering or even thought about how criminals might exploit your business. And we'll all get better with this as time progresses and as people become more familiar with the regulations and more familiar with looking at suspicious activity and reporting that suspicious activity to us. But we certainly don't expect perfection from day one, but we do expect honest efforts to comply with the law. Katie, anything else you'd like to add to that one?
Yeah, I think in terms of our sort of enforcement posture, in the early days of these new obligations, we will be focusing our enforcement efforts on people who willfully don't comply. So we're thinking there of people who should be enrolled because they are providing designated services but do not enroll. So that's the first category of people. And the second is lawyers or businesses that we suspect are complicit with organised crime to launder money, so are knowingly participating and assisting organised crime to launder money.
Thanks, Katie. What about the issue of duplication? People have asked about, again, financial businesses are already regulated. They're already collecting KYC information on customers. They're already reporting to us. Does this new regime create any unnecessary duplication in processing and dealing with clients? Katie, have you got a thought on that one?
In terms of the information that is gathered, I would sort of go back to that point around it's not duplicating the information, it's providing a different perspective on the transaction. Where you do have transactions that have multiple regulated businesses in them, and I think the property transactions are the obvious one, the rules do provide for reliance on another party's customer due diligence processes. Now, to be able to take advantage of those reliance provisions, you do need to have a documented agreement with the other party. But that's one example of where we don't want clients being asked for the same information, 4 or 5 times. So there are provisions to be able to have an agreement, whether it's a one-off or maybe there's a group of real estate agents or banks that you deal with regularly so that you can have that ongoing reliance arrangement.
Yeah, it's really important to know that the law is specifically tailored towards those kinds of transactions to allow information to flow between reporting entities. And we expect as the regime goes on, industry will develop some more mature ways of doing that more effectively and more efficiently. It's a question here about what's the overall outcome that AUSTRAC expects from these reforms? Well, to my mind, we want to make it harder for people to launder money. That's effectively what we're about. We're not about catching out people for minor compliance breaches. We're about making it hard for people to launder money. That's the reason why we exist and the reason why these reforms are being put in place. And so what we're hoping is that through a greater awareness of suspicious activity of criminals and a greater understanding of how people launder money, you'll be able to put in place controls, one, to identify when those suspicions occur, and secondly, to take action to stamp out crime when you see it touching on your business. But really importantly, and I can't stress it enough, is to report suspicion to us. We do a lot with the information that we get from the businesses that we regulate. We work with all the law enforcement bodies in Australia, all the state and federal police forces, national security agencies, and lots of international countries sharing financial intelligence about crime and criminal networks. And often the strength isn't in the individual report we get from a business, but it's in the cumulative information we get on multiple reports on the same entity or multiple reports even on the same transaction. It gives us really rich pictures around criminality and helps us sharpen the intelligence that we give to law enforcement for them to be able to do the job that they do. And the data that we get from, and hopefully that we'll get from all of you, isn't just available to us in our financial intelligence, but is available, as I said, to all law enforcement. They can directly go in and access that material, and they do, and they use it regularly. By way of an example, the New South Wales Police Force used the AUSTRAC database more than 1 million times last year. It gets used all the time by law enforcement and national security bodies. So what do we expect? One, we expect hardened services so that criminals can't exploit those, greater intelligence, and the greater ability for us nationally to crack down on money laundering and organised crime. There's another question about legal professional privilege. Katie, I might throw this one to you. What's the status of legal professional privilege under these reforms and how should it be dealt with?
Yep. Okay, so the key point is that the law does not override legal professional privilege. If you have a suspicious matter and in providing a report about that suspicious matter, you have legally privileged information, you do not need to disclose that privileged information to us. You will need to fill out a separate form that lets us know that you are making a claim of legal professional privilege, but you do not need to provide the privileged information to us. So that's the first point. The second is that when it comes to other legal professional obligations, the law does override some of those. So if you have a duty of you will have a duty of confidentiality, the law does override that. So in submitting a suspicious matter report, you do need to disclose information that would otherwise be protected by that duty, but you do not need to give us legally privileged information. There has also been sort of discussion about, well, what if you submit a suspicious matter report about your own client, can you continue to act? From the perspective of AUSTRAC as an AML regulator, we do not have a view about that, but I know that it is something that the professional bodies will be providing guidance about. So my strong recommendation is that when you come to submit your first suspicious matter report, my strong recommendation is that you get in touch with the ethics section of your local state-based professional body and just work through how some of the other duties that you have both to court and client might need to be considered as you develop the suspicious matter report.
Thanks for that, Katie. I mentioned earlier that we'd bring this session to a close at 7 o'clock, and we're almost right on 7 o'clock this evening. I just really want to thank you all for taking the time to join us for this information seminar this evening. We really do appreciate you taking the time to log in and learn more about these reforms and your obligations under these reforms. Really hope this session has been useful for you and give you some greater clarity and confidence about these reforms as we move forward together. As Katie mentioned earlier, we have a check if you may be regulated tool on our website. Really encourage you to jump online to the AUSTRAC website. That's austrac.gov.au and use that tool to see if you'll be regulated. Also really strongly encourage you to subscribe to our In Brief, our monthly newsletter. And that newsletter will keep you updated with a whole bunch of reform activities and other work that we're doing. Our website also has a dedicated reform page, so please get on and have a look at that and have a play around with the information that's available on that site. And hopefully, if you've got further questions, we should be able to answer them through material that's on that site. And we're constantly updating information on that site, so keep your eye out for that site. And also, I really strongly encourage you to continue to engage with your industry association, your peak body, the Law Council or law societies. We're working very closely with all of those bodies, and they're continually putting out more information, holding more sessions and producing more material to educate the legal profession about the responsibilities that are coming in July. And finally, you can see this and some other material on the AUSTRAC YouTube channel, and you can see the address of that YouTube channel on the screen. Again, thank you again for taking the time to join us this evening. Log on to our website and stay in touch with us. There'll be more information coming out between now and July to help you understand these obligations. And I hope you have a good evening. Thank you again.